Good afternoon, sir. Good afternoon, sir.
Wait.
Good afternoon, sir. Sir, can you hear me? Good afternoon, sir.
Mic option ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಸುತ್ತೆ ನೋಡೋದು. ಕೊಟ್ಟಿದ್ದೀನಿ. ಸರಿ.
Yeah, now I could. Good afternoon.
Good afternoon, sir.
Yes, ma'am. Now I am there online.
Yes, sir. Everything on can you see me? No. Okay, great.
ಇಲ್ಲ ಇಲ್ಲಿ ಮ್ಯೂಟ್ ಇದೆ.
Professor Raghunath, good afternoon.
Good afternoon, sir.
Good afternoon, one and all gathered here, and everyone logged into the Zoom ID. I request the dignitaries to come on to the dais and to occupy their seats. Participants, kindly note before we proceed, please mute your devices so that it does not cause any unnecessary disturbances. As Albert Georgi once said, a renowned Hungarian physiologist, research is to see what everybody else has already seen and to think what nobody else has thought. These profound words capture the very essence of our course today, a journey into the art and science of research and legal writing. Good afternoon to one and all gathered here and logged in. I, Amoga Gadkar, Assistant Professor of Vaikunta Baliga College of Law, Udupi, welcome the respected Chief Guest of today's inaugural occasion, Professor Dr. Chidananda Reddy S. Patil, Director of KILPAR, Bengaluru.
Thank you. Thank you very much.
I also extend a hearty welcome to our beloved principal, Professor Dr. Raghunath K.S. Also, I welcome our director, Professor Dr. Nirmala Kumari K. Further, I welcome our Coordinator of Research and Publication Committee, Dr. Jayamol PS. Furthermore, I welcome our HOD of Law and Student Welfare Officer, Srimati Surekha K. And our PTA President, Srimati Vinuta Kiran. Also, I welcome the President of our Student Executive Council, Mr. Sridhar. This course was originally designed for students and research scholars with the objective to foster research skills. Now, it has been expanded to include teachers due to overwhelming response from the academic community. We are delighted to convey that over 246 participants have registered from across various states of India. And we also have 5 participants from Afghanistan and 1 from Pakistan. Welcome to one and all. To begin this momentous occasion on an auspicious note, I invite our talented students to invoke the blessings of the Almighty through a prayer.
करुणानयना मदगजवदना करुणानयना मदगजवदना पार्वती नंदना माडिरे वंदना करुणानयना मदगजवदना ಶಿವನಾಗಮನ ತಡೆದ ಗಣೇಶ ಶಿವನಾಜ್ಞೆಯನು ಪಾಲಿಸದೆ ಶಿವನಾಶೂಲಕ್ಕೆ ಶಿರವನು ಕೊಡುತ್ತ ಗಜಮುಖನಾದ ಗಣಪತಿ ನಂದನ ಗಜಮುಖನಾದ ಗಣಪತಿ ನಂದನ ಕರುಣಾನಯನ ಮದಗಜವದನ ಮದಗಜವದನ ಮದಗಜವದನ
Thank you, Ms. Vidhi, for a soulful invocation. A warm welcome is like a sunrise that brightens the day. To officially welcome everyone gathered here, I invite our beloved director, Professor Dr. Nirmala Kumari ma'am, to deliver the welcome address.
Respected dignitaries on and off the dais, and also participants present online. Good afternoon, everyone. Welcome to our program today. At the outset, I wish to tell we are honored to have such a distinguished group of teachers and students joining us. The program promises an engaging and enlightening experience for all of us. We are conducting 7 days certificate program on research and academic writing. Writing a well-researched article enables teachers to stay updated on cutting-edge knowledge, complementing their classroom teaching with pragmatic and contemporary insights. Getting it published, these research papers invite further exploration and stimulates critical thinking among readers, scholars, fostering a culture of intellectual inquiry. Furthermore, teachers are typically required to publish a minimum of certain articles, making research a compulsory aspect of their academic pursuits. So, it's a befitting program for both teachers and students. For the first day of the program, we are honored to have with us Professor Dr. Chidananda Reddy S. Patil. He has acclaimed several positions as the Principal of University College of Law, Professor and Director of Karnataka State Law University's Law School, and also for some time he was the Vice Chancellor of the university. I wish to tell you a special thing about him that when he got promoted as the Director of KILPAR from KSLU, His farewell was commemorated with a public felicitation, a souvenir publication, and a creation of an endowment lecture in his name, which was a testament to his lasting impact. Now, as the director of KILPAR, he has drafted many legislation for the government of Karnataka. He has written many more, drafted many more legislations. He has received a commendation for his work in the field of human rights. He was a member of the expert committee for establishment of Karnataka Rural Development and Panchayat Raj University. The bond between Dr. CSP sir and our members of the staff and our college is lovable, affectionate, and divine. Our students are much familiar to him. He is well known for his engaging good speeches. He has a unique ability to make complex legal concepts accessible to all. And another specialty is that his recommendations for essential law books have guided many students to buy books and read it. It's with great pride and honor I welcome today's chief guest and inaugurator and the keynote speaker of the program, Sir Chidanand S. Patil. On behalf of the management, myself, staff, PTA, and students of Vaikunta Baliga College of Law, I extend cordial welcome to you, sir. Welcome you, sir. I welcome our beloved principal, Professor Dr. Raghunath. I extend you a cordial welcome, sir. We received a good response from teachers and students for this program to our invitation. Almost participation from Kerala, Karnataka, Tamil Nadu, Assam, Delhi are attending this program. I extend you all warm and affectionate welcome. I also acknowledge the presence of Mrs. Kiran Vinata, President PTA, and other members. I extend them, all of them, a warm welcome. To place on record my affectionate welcome to Dr. Jayamoon, the coordinator of the program, Mrs. Sureka Madam, Students Welfare Officer, my esteemed teaching and non-teaching staff of Vaikunta Baliga College of Law, student coordinator Shwetana, the presidents Shida Nayak and Bhargav Nayak, students council members, and also my dear students for this program. I welcome all of you. Thank you very much.
Thank you, ma'am, for setting a tone for the day. Now, I take great honor to introduce our chief guest of today's inaugural occasion. Professor Dr. Chidananda Reddy S. Patil is a scholar at par excellence with a career that embodies dedication to legal education, research, and reforms. Sir began his academic journey with a Bachelor of Science degree from University of Mysore in 1983. Following this, Sir pursued his LLB at University College, Dharwad, completing it in 1986. In 1988, Sir earned his LLM in Constitutional Law from University of Mysore, securing first rank, for which Sir was awarded 2 gold medals and cash prizes by both Mysore University and Government of Karnataka. Further advancing his scholarship, Sir earned a doctorate in law from Karnataka University, Dharwad. Sir has a renowned teaching career spanning over 3 decades and has imparted knowledge at esteemed institutions such as JSS Law College, Mysore, HA Law College, Dharwad, KLE's Law College, Bengaluru, University Law College, Dharwad, KSLU's Law College, Hubballi. In his tenure at KSLU, Sir has held numerous leadership positions including Acting Vice Chancellor, Dean, Director of KSLU's Law School for a period of 7 years, member of Syndicate and Academy Council. Sir currently serves as the Director of Karnataka Institute for Law and Parliamentary Reforms, KILPAR, Bengaluru. Sir contributes to legal scholarship are remarkable. He has authorized 1 book, edited 4, and published more than 85 articles. Notably, he contributed a research paper to the Committee on Reforms of Criminal Justice System, chaired by Honorable Dr. Justice V.S. Malimath. His expertise extends to drafting legislation for the government of Karnataka, including the Karnataka State Human Rights Court Rules 2006, for which he received a commendation in 2010. A passionate advocate for community service, Professor Patil has actively engaged in legal aid and literary initiatives for over 25 years. His involvement in curricular, co-curricular, and extracurricular activities reflects his holistic approach to education and reform. Sir, we are privileged to have your presence here today. On behalf of the entire UBCL family, I extend you a hearty welcome. Now, ladies and gentlemen, please join me in welcoming today's chief guest to address the gathering.
Thank you very much. It is always an outstanding privilege and pleasure to be associated with Vaikunta Baliga College of Law. I have a plethora of reasons for that. Starting from the distinguished scholars who are in the faculty, who are very warm and affectionate, carrying forward the culture that was initiated by their predecessors, the disciplined environment in which the students groom themselves and excel well in the legal education. And it is always so good on the part of UBCL to associate me, and wherever I am working, the institution, in their collaborative exercises. Distinguished Principal Dr. Raghunath, Director Madam Nirmala, Dr. Jayamol, Dr. Surekha, Madam Vinuta, and the young student representative Sridhar, distinguished faculty members, the participants who are there online as part of this certificate course, and all those who are present here. Certificate course in research and academic writing. This is a very, very unique and innovative idea with which the faculty of UBCL came out with. They wanted to collaborate with the Karnataka Institute for Law and Parliamentary Reform, which is basically a research institution which undertakes a lot of research in the field of law reform, evaluating, examining the existing legal framework and pointing out the deficiencies that are there and improving the law and enacting the new legislations wherever necessary. And we in KILPAR felt this is a very wonderful exercise which is embarked upon by UBCL, and we readily agreed to collaborate and contribute our own bit towards the exercise in which the great institution is involved in. See, there are so many dimensions of lawyering. And as the students of law, all of us should acquire ourselves with different dimensions of law, different dimensions in which the law affects the society and interacts with the society, and the different dimensions of activities that we can undertake as legal education institutions and as students of law. Research is a very, very basic and essential component of any activity of any lawyer. And that's why we had to introduce that subject, legal methods, in the undergraduate program, and at the PG levels, we have the research methodology itself as a full course prescribed. When we look into the objectives of the course, certificate course for which we are all here on the platform and physically present, it is very clearly defined. The object is to promote in students the research skills and writing skills. These are very, very important for lawyers. Legal research and writing skills. It is to enable the students to come out with research output, knowledge creation. And then they should be inculcated the ability to follow the style manuals, referencing system, footnoting, which is very, very essential and technical. And at the end of a program, at the end of a course, you should be in a position to write it automatically, spontaneously, without committing an error. That is the level of styles that we have to cultivate. Then we have the issues of plagiarism. We have seen the best of the scientists, best of the scholars running into the issues of plagiarism, and movie makers have run into plagiarism, musicians have run into all these things, and we should know what is plagiarism and how we can avoid that, and to what extent citing, quoting is permitted. And beyond everything, we should cultivate research ethics. That is very, very important, especially in the field of social science like law. So the course design is all comprehensive. And when we look into the array of resource persons, Professor P. Ishwar Bhatt, Dr. Naveen, Professor Venugopal, Professor Anish Pillai, Mr. Syed, and Dr. Venkatesh from the library science, then the epitome, Professor T.R. Subramanian. See, all these people who are resource persons are going to give you loaded components. Each person is an authority in the field that is mentioned against their names. And not only that, they are a bastion of scholarship, which is to be explored on different occasions. And this is a very well-conceived program, well initiated by VBCL. And this is the area which was remaining mostly untraversed in many a number of institutions. See, complying with the requirements is different. Showing compliance is very, very easy. But rising up to the quality standards to which a person who has complied with the requirements has to rise up to is the essence. And the very fact that 200 and odd people have enrolled themselves for this program speaks volumes that really people are interested in qualitative improvements. And that is a gesture which will encourage the organizers to take further steps. Okay, with that brief outline, we will look into why the skills of research, where is the need, why there should be acquainting ourselves with the tools and techniques of research, and especially academic writing. Okay. See, whenever we conduct any research, whenever we find anything, whenever we discover anything, these things are to be communicated to others. Otherwise, what is the purpose of inventing, discovering, or recreating? In other words, any research is to be reported to the public at large. Report is to be published because the purpose of research is adding to the knowledge, contributing to the existing knowledge is research. So that has to come out in the form of a research report. And this report at the end of research, maybe it is in the form of a pleading, maybe it is in the form of an essay, maybe it is a monograph, maybe it is a thesis, maybe it is a dissertation, maybe it is a conveyance, maybe it is a case memorandum. Depending upon what is the research you are involved in, the output will take some shape. And whatever we write at the end of research, legal writing, should be supported by reasons. It should be supported by reasons. It should be supported by arguments. There should be references. And there should be relevant evidence. See, unless these things are there, research will not be credible. Research will not be credible. And for credibility of research, there are various other requirements like integrity, honesty, objectivity, etc., which will be covered by the distinguished resource persons which are lined up to address you on different occasions. Okay, that is the requirement. The research writing is an expression of what went on in the thought process. Later you will be learning something about reflective thinking, reasoning. Okay, so what went on in the thought process? What interpretation of data has taken place in relation to research questions? What are the conclusions that are arrived at? What are the observations that are made? What are the inferences that are drawn? All these things are to be encapsulated in the legal writing, the way it is to be done. Okay. So there are various dimensions involved in research writing. A research writing is an exposition of research work which the scholar has undertaken, which the professional has undertaken to the world. I have to exhibit it to the addressees. Maybe I am submitting a report, research report to my sponsoring agency, maybe my government, maybe my industry, maybe my senior advocate. So this is exposition, which involves, look at these things, elucidation, expression, description, analysis, evaluation, etc., etc. See, in the research writing, all these things, depending upon the requirements, all these things will be pressed into service. What is required is a research writing should reflect mature display of original thoughts in relation to facts and in relation to law, in relation to judgments, in relation to opinions that are expressed. What are the prevalent values? What are the prevalent views? What are the prevalent practices? What is the social reality? See, upon this, one should reflect and come out with original thoughts. Electoral bonds judgment. What is the value of the judgment? We have to evaluate as researchers. Did it do anything good by quashing the electoral bonds scheme unconstitutional? the scheme was introduced to weed out black money. And if you quash that scheme as unconstitutional, black money will flow in. And through unconstitutional means, parties have gathered crores of rupees, thousands of crores. And with that, they went for elections. A common man looking at this, he'll say what type of judgment it is. Analyze, describe, evaluate, and check what has happened is right. What is the quality? What is the contribution? Critical aspects. So, Personal Digital Data Protection Act. Evaluate that. What is the type of protection that is there? What is the type of model, whether it is consent-based model, whether it is duty-based model? What type of model is adopted here? What is the liability of the platform? What is the liability of the fiduciary, etc., etc.? See, as researchers, we have to study, understand, conduct research, and bring it to the public world so that people can discuss, debate, or at least understand. And see, according to this is up to a point, according to this. Beyond that, we should be in a position to say, in my considered opinion. Okay, I am a lawman, I am a trained person, this is the research that I have conducted, and it is my considered opinion that, okay, that is the level to which we should be in a position to put things across, and that's what that is tried to be achieved at the end of administering this program. Okay, so when we publish this, there should be a possibility of expressing original thoughts. Original thoughts are very, very important. See, you may say, I am a young teacher, I am a law student, where from I will entertain one. See, mind is such a wonderful thing. If you cultivate the brain, you can develop any amount of analytical skills. It is a thinking process. Swamiji has said, mind your thoughts. Swami Vivekananda. Thoughts make paths in the brain. They will make highways in the brain. And you will be so familiar to traverse through those highways. Thoughts are very important. That's why we speak in terms of reasoning and reflective thinking. When we speak of legal writing, it will take three forms majorly. Let me be very clear. The idea and methods of research, the book, Idea and Methods of Research, authored by Professor P. Ishwaravat, is a treatise on research methodology for law people. Till this book, we did not have any quality research methodology book for us, for the field of law. And we should feel so proud that this is the book which is published by Oxford University Press. And I am speaking today heavily relying upon what Professor Ishwar Bhatt has written in that book. I very strongly and seriously recommend everyone to acquaint themselves with this book. It is not a book to be read. This is a book to be studied. Every para is loaded, and people who want to pick up, they will pick up as much as they want. It is like a river of knowledge that is flowing. I can take a jug, I can take a mug, I can take a glass, I can take a bucket, I can take a pot. That is the type of book. And if see, you have to read it gradually, few pages a day, topic wise. You will be really benefited, especially those who are in the field of academics and those who are in the lawyering fields. It has a lot of information to give. There are three major types of legal writings. One is instrumental legal rating. See, these are the expressions of Professor Ishwar Bhatt. Instrumental legal rating. What is instrumental legal rating? Communicating submissions, instruments, pleading is an instrument. Written statement is an instrument. Claim form, defense is a legal instrument. Instrumental legal rating involves communicating submissions, ideas, information, and documents, which are foundation of claims and obligations. So you have the examples of plaints, petition, affidavit, conveyance, like sale, mortgage, lease, etc., etc. These are the instrumental legal rating. The question arises, in what way research rating is connected with instrumental legal rating? Any person, deed writer, he is there, he will write that deed, CL deed or whatever it is. That is the crude form. See, when it comes to the point of technology transfer agreements, mergers, takeovers, see, there are veritable areas in which we have to exhibit our skills. So instrumental legal rating requires lot of research if you have to come out with quality output as a research rating. Second is norm creating legal rating or implementing legal rating. Norm creating legal rating. See, norm creating legal rating involves formal and official sources of law. It may be treaties, it may be different conventions. You have Convention on Elimination of all forms of discrimination against women. You have various types of treaties, right from Vienna Convention and Law of the Sea, veritable things. Then Constitution is a norm-creating instrument. Writing Constitution is norm-creating. See, if you read that book of Lawrence Tribe, Making the Constitution, so what is this? Reading the Constitution. You have to read this book, Lawrence Tribe, Reading the Constitution. I am really fascinated by this book. The first chapter is how not to read the Constitution. And a subheading under this chapter is reading the Constitution should not be writing the Constitution. Such a marvelous treatment. And in the acknowledgements, you have the name of Barack Obama. Barack Obama has helped in perfecting this book, and Lawrence Tribe has acknowledged the contribution of Barack Obama. Barack Obama, who later became the President of the United States of America. Look at that. People at that level also are involved in serious legal writing. Okay. See, you have to have glimpses of Constituent Assembly debates to understand how complicated the constitution making process was. I will just give you a glimpse. When Sir B.N. Rao was invited by the Constituent Assembly, at the same time he was tipped to be elevated to probably Calcutta High Court. Had he accepted, I am told, he would have become the first Chief Justice of India. But B.N. Rao opted to go with the countrymen towards constitution making. He has written to the British government saying that, look, you have given me this offer. At the same time, I have received an offer from my countrymen who think that I know something in constitution making. At times in life, people will be at crossroads, and now I am at crossroads, and I prefer to go with my countrymen and serve the nation. So he went and joined Constituent Assembly. To tell you how beautiful the Constitution is, go to Article 395. Independence of India Act is repealed. Government of India Act 1935 is repealed. The simple question arises whether an act of British Parliament can be repealed by the Constituent Assembly of India. The answer is yes, because it is an equal sovereign with the British Parliament. If you can go to the extent of legislating about our country, we will repeal that law. Organization of sovereignty within the constitution is one of the basic principles of a complete constitution, which we were taught when we were students of first LLM. Organization of sovereignty with constitution making is a highly technical activity on the part of a population to create a document. It is a bold experiment to create a document which will govern the creator and all the institutions through which are created under that document, and which will take the nation in a particular direction. Constitution should not fail. And look at the strength of our constitution. It has not failed 75 years, and the celebration of constitutional democracy goes on. It is all because of the strength with which this document is written. So that is the norm creating legal rating, which will take the form of constitution, which will take the form of legislations, which will take the form of government orders, etc. There is lot of research that goes behind making all these things. Right now, as part of this institution, we are involved in suggesting law reforms to the government, drafting new legislations, and the type of research that we undertake for this purpose, you will not believe. We cannot take anything for granted, because whatever law that is going to be enacted will affect the whole of the state. It is lot of responsibility, and this responsibility will make you to doubly think, verify yourself, try to arrive at the true things. That is the requirement here. And the third type of legal rating is critical legal rating. Okay, critical legal rating. What is this? Research reports, which will come in the form of dissertations, theses, assignments, articles, books, treatises, monographs, comments, book reviews, etc. See, this involves critical legal rating, involves higher level of critical thinking. I tell you, this is recently I completed reading one book, You Must Know Your Constitution, by Fali Nariman. I started reading Constitution in 1983 when I joined my LLB. As a first LLB student, I started reading the Constitution. From 1983 to 2023, 40 years I have read the Constitution. At the end of that, I get this book, You Must Know Your Constitution. Fali Nariman, when Fali Nariman says, you must know your Constitution, I said, I will read this. Let me try. I must know my Constitution. I started reading book. Such a fascinating book, my friends, I tell you. For the first time, I came to know that there is no fundamental right in Article 21A of the Constitution. He says there is no fundamental right to education. And his argument is, look at the latter part of Article 21A. By amending the Constitution, they have converted a thing which was a fundamental right at the end of the Supreme Court judgment into a thing which is not even a statutory right. Forget fundamental right. And he proves that. Yes, I must know my Constitution, as analyzed and as presented by that great jurist we had. And I paid a tribute to the memory of Fali S. Nariman by reading his last book. With that, I have read all the books that are written by Fali Nariman, and I suggest, if you are not reading the books of Fali Nariman, whether it is Crisis of Indian Legal System, whether it is State of the Nation, whether it is Harmony and Disharmony, whether it is Before Memory Fades, whether it is God Save the Honorable Supreme Court, you will be missing something terribly. Please, please read. You have enrolled yourself for research. You need not accept and agree what Fali Nariman has. Critically think and reject with justification if you are not in agreement with what Fali Nariman has said. So critical thinking is very, very essential, whether it is judgment of a court, whether it is an amendment brought in or whether it is a law enacted, we have to have this critical aptitude we have to develop, and that should be reflected in writing, that is legal writing, critical legal writing, maybe in the form of dissertation, maybe in the form of an article. See, when you Google, you will find that lot many articles are written by law students. And nowadays we are stumbling upon more articles, more commentaries written by students than the law professors. How is that possible? It is possible because these are the people who are at the table, who are reading and critically evaluating. And they publish it for the information of public. Okay. Then the importance of legal writing. Why we have to write and publish? See, the objective of research may be exploration. I want to explore a field of knowledge. Maybe the purpose of writing is explanation. That is a very complex, critical area which I want everyone to understand. I want to explain. Maybe some of the writings may be plain. See, for example, I tell you, constitutional law students will discrimination on the basis of sex is prohibited in 15(1). There shall not be discrimination on 1, 2, 3 grounds, on ground of sex also. 15(3) says, nothing in Article 15(1) shall prevent the state from making special provision for women and children. As far as woman is concerned, that is fine, I understand, because discrimination on the basis of sex is prohibited. There should be an exception in 15(3) to make laws for the benefit of women. But why children is included here? Age is not a prohibited ground under 15(1). When age is not a prohibited ground under 15(1), where was the need to add this word child? A person of one level of information will say this is superfluous. Constitution makers probably forgot that they have not introduced age as a prohibited ground, and that's why unnecessarily they have created this exception. But a matured constitutional law student will say, look, the constitution makers wanted to raise the protection of interests of the child to the constitutional level. That's why they have mentioned the word held also in 15(3), not in the form of an exception to 15(1), but to express their concern and commitment to protect the interest of the child. The perception varies depending upon how, see, explain, we have to explain. We have to explain the provisions. We have to explain the concepts. We have to explain the ideas. So research may be for the purpose of explanation. Research may be for the purpose of description. It may be for the purpose of analysis. It may be for the purpose of law reforms. The research is undertaken with various purposes. And depending upon the purpose, the report will take different forms. Okay. So what is that report? Research writing, that output that comes at the end of that. It is an instrument. It is a document which will be carrying. It is a vehicle of some beliefs, some opinions, and it may result in some law reforms. If there is any unsatisfactory condition, it may result in improvement of that unsatisfactory condition. See, all these things are possible when the research is published. Okay. So, see, other day I stumbled upon an expression. Scholarship is an enemy of simplicity. See, if you are a scholar, You are an enemy of simplicity. You have to write in simple words so that people understand. If you have read the books of Lord Denning, please read. Now Indian editions of Lord Denning's books are available. Start with family story, his autobiography. Closing chapter, what next in law and law, discipline of law, due process of law. All of them are worthy of reading. Wonderful books. And you open any page, there is a subheading. The language used is so simple, you need not touch a dictionary to understand what Lord Denning has written. Such beautiful, simple writing. So why he has written? He has written to make us understand, to convey his ideas. Whatever he wanted to communicate, he has communicated straight. That is the clarity that is required. So scholarship is master of simplicity. At the same time, it is an enemy of simplicity. Some people make simple things so complex and they project themselves as scholars. Some scholars make so complex ideas so simple, then communicate. So when we write, this writing, which is revolving around certain of the hypotheses, research questions, objectives of research, etc., that should be presented with justifications and references. People should be in a position to accept and believe. Look, this is on the basis of XYZ things. That's why we have to accept this. That is one thing. And second, why we write? We write to communicate. Okay. Writing should have quality of communication to the reader in the same sense in which I have understood it. I have conducted research. I have understood it in a particular manner. When I have written it, when you read it, you have to understand it in the same manner in which I have understood it. That is the type of clarity that is required. I write one thing and you understand a different thing, then I am not communicating. That will not be a good research writing. Okay. So it should be written in such a manner that the reader also understands it in the same sense in which it is intended to be understood. And second, there should be clarity in what you have written and there should be readability. Clarity and readability is very important. And there should be sufficient discussion and interpretation of data so that this discussion and interpretation answers whatever questions you had set at the beginning of your research. And the questions are answered in an objective manner with value neutrality, with authenticity, with the justification. Okay. So there are certain of the mandates. Research well, abstain from misstatement of facts, avoid suppression, correctly represent the law, whether you like or not. These are the mandates of research writing. And one of the hallmarks of research writing should be readability. I was putting the example of Lord Denning, and you can take the contrast of Justice Krishnaiyer. Justice Krishnaiyer tends to be verbose several times. But the clarity that is there in Lord Denning's is appreciated by everyone. Readability can be promoted by choice of language. What words I will use, what expressions I will use, and the writing style. Choice of language and writing style will promote readability. The recommendation is use appropriate word. use appropriate word. It should be simple, but it should be strong enough to convey what you wanted to convey. Okay. Formulation of sentences should be born out of togetherness. There should be nothing in the sentence which is out of place. The sentence will be complete whole in itself. Okay. And there should be a single thought running through a paragraph. See, each capsule of thought process should be kept in a separate paragraph. Okay. And you have to cultivate elegance of language. See, language should be so soothing on the ears, so flowery to read through, to listen. See, cultivate elegance of language. But at the same time, you have to bear in mind that language should be understandable to the society and the legal world. Where I am speaking, for whom I am writing, that society should be understandable, should be understanding in this language. So if we use certain of the expressions that are used somewhere else in our system, maybe, say, for example, mistress. Mistress has a different meaning in England and mistress has a different meaning in India. We should understand for whom we are writing. Okay, so keeping all these things, we have to write about whatever research that we have undertaken. When we perform different tasks as lawyers, we have to conduct research. We have to draft documents, plaint, written statement, claim, defense, applications, etc. Okay. Therein again research skills are involved. Therein we have to divide this activity into three stages. One, we have to understand what is the purpose. When I am engaged as a counsel, as an advocate by a particular client, he has engaged my services for what purpose? What is that I am supposed to do there? The purpose is maximize gains and minimize losses for my client. Or interests ought to be served. What is that I am supposed to protect? What is that I am supposed to save for the good of the client? This is the purpose. And for this purpose, what is the activity that is required? I have to understand what is the problem. And I should go on researching. It may be preparation of a document, it may be giving a legal opinion, it may be preparing arguments, it may be a memorandum, whatever it is. For that, what is the activity required? So all aspects of organizing the information, performing different tasks of legal research and legal writing are involved in this activity. And the third one is subject matter. Subject matter is about law and legal institutions. Okay, if this is the remedy which my client wants, what is the law? What are the legal institutions which I should approach for the purpose of protecting the interest of this client, or to register this document, or to enforce this document, whatever it is. So research is involved in academics, in professional activities, everywhere. And writing about research, it will take different forms, as I have told you initially. While researching, we should be very, very meticulous in noting things and minute details. Beauty lies in minutes. That is one of the standard quotes that we come across always. There should be intensive churning of thoughts, credible ideas. See, when this churning takes place, credible ideas will emerge. And it all depends upon thought process. And in all legal exercises, in all legal instruments, what is involved is 80% thinking 20% writing. 80% thinking, 25% writing. So when you have to write an article, you have to have a mental outline of what you are going to write. Then go on collecting information, collect data, analyze, synthesize, and once it is there, see, it is stated, everything is created twice, once in the mind and later in the physical world. Okay, so mental outline of the product should be there, and that mental outline should be converted into formal outline by sketching it as synopsis, go on filling it, and it becomes the document that you want to produce. What is required is continuity of thought, logical sequencing of paragraphs, and by practice, you will gain mastery over this. There is a saying, the real test of authorship, is not in writing, it is in rewriting. The test of authorship is not in writing, it is in rewriting. We have to write and rewrite several times. And some of us who are the graduates of Mysore University are well aware of the fact how many times we have rewritten some of the chapters of our dissertation. When we look back, on that day, when professor asked us to rewrite, we felt terribly bad because there was no typing manual. Each chapter running into 40, 50 handwritten pages, and you have to redo the whole thing, research again and redo. But we are in whatever position we are today, we have whatever respect we have today. See, it is all because of that constant, thorough grinding that we underwent at the hands of our professors in the University of Mysore. And that's why we remain beholden to all our great teachers. And somewhere, the former Vice Chancellor of National Law School, Professor Madhav Menon, repeatedly he was telling, the teachers of that generation and the students of present generation would have made a wonderful combination. But unfortunately, that has not happened. You have to your fate the students of those teachers, and we are striving to do well to serve the system to the extent possible. And that is manifested here through what Professor Nirmala Kumari and Professor Raghunath, with the help of his faculty members, involving all those great graduates and professors of Mysore University and the cognate people have conceived. And it is a privilege for us in KILPAR to be associated with BBCL in this wonderful activity. And I consider it a unique opportunity that is given to me to inaugurate this program and also deliver keynote address, which I have done with utmost respect and with utmost love and affection. Thanks everyone for the opportunity given. Hope to meet all these people physically when the time permits. Thanks a lot. Over to the organizers.
Thank you, sir, for your thought-provoking address and elaborately expounding on wide range of issues such as scope of discourse, process of research, traits of a researcher, and kinds of legal writing. Thank you, sir. Now, as we approach the end of this inaugural section, it is time to express our immense gratitude. I invite our respected principal, Professor Dr. Raghunath K.S., to propose the vote of thanks.
Inaugurate of discourse. Professor Dr. C.S. Patil sir, and other esteemed guests and faculty, and my dear students, and all the participants who have participated in this today's program. I am honored to propose a vote of thanks on this significant occasion, marking the inauguration of a 1-week certificate course on research. Informally, one day I called Dr. CSP over the phone, and I told him, sir, this is the thing what we are doing. Can we use the name of KILPAR? He readily agreed. Next day, I asked our Jaya madam to write a letter to KILPAR. Immediately responded, and he agreed to collaborate with us for this academic activity. And he also agreed, in spite of his busy schedule, to inaugurate this course. On behalf of Vaikunta College of Law and all other participants, I thank you very much, sir. I also express my grateful heartfelt thanks to our director, madam, Dr. Nirmala Kumari, for supporting us in all our endeavors. Thank you, madam. I should thank all the participants from different law colleges and all my faculty members, particularly Jaya madam, since 1 month she is on this particular. Vinita madam is not there. I should thank President of PTA. Whenever I approached Vinita for anything, for funding or anything, for academic activity, she stood like a wall and supported me in all our academic activities. This time also, she readily agreed to fund whatever we require for the certificate course. I express my grateful thanks to PTA president and all the executive members of that PTA. Thank you, thank you.
Thank you, one and all gathered here, and also those who are logged in on Zoom ID. We ask for your sincere cooperation for tomorrow's event as well. Thank you. Thank you, sir.
Sir left.